the taking over of media control in July of 1990, the dismissal of Albanian healthcare workers, again in 1990, and of course the abolition of the Kosovo education system, also in August 1990, and then the laws in 1991 bringing police from Yugoslavia to replace dismissed Albanians, and thus bringing a police domination of Kosovo. But you will find that there is indeed evidence of a lower level of violence occurring in Kosovo as early as that period of time. And so what was happening, what may be described perhaps as low-level ethnic cleansing with police raids and Serb police joining paramilitary squads in violence in, for example, Leposavić and in Mitrovica. Now, I mention that because although, yes, a strict temporal change brings its difficulties, those events happening right at the early part of the 90s, continuing with interference with human rights, we will argue, throughout the period of time of the other conflicts, and matching them, shows that although you have before you, and have for the purposes of these very grave crimes, the isolated events of 1999, in fact, they were themselves, as it were, part of an overall plan which encompassed, not just as bookends as we put in the motion, but encompassed and infiltrated the other events. Now, those earlier events don't need to be charged and couldn't be charged maybe, or it wouldn't be worth attempting to charge them because of their comparative lack of gravity. But they were utterly revealing of, consistent with, and part of what happened overall. And so, of course, if one of the shortcomings is in the drafting, we regret that, apologize for it. If we could have, when the Kosovo indictment was drawn, have thought our way through all the potential legal needs, we might have done things differently, but we didn't.
It's not only in the drafting. There is a fundamental problem, as Judge Robinson has said. How is the trial chamber to be assisted, or what is the relevance of, to put it another way, events in Croatia and Bosnia in 1991 and 1992 to events in Kosovo, a part of Serbia, part of the Federal Republic, in 1999. These appear to be different events, and different considerations apply to them. Now, it may be, and you may like to consider this, that there is an argument for saying that Bosnia and Croatia should be tried together, both involving, as they do, the same type of conflict in that they involve neighboring states, the same type of responsibility as alleged, it should be said, in the case of the accused, that is, acting indirectly and through others, as opposed to the case of Kosovo, which not only comes later, but also involves, as far as I can see, a different type of responsibility. In the case of Kosovo, this was part of the Federal Republic, of which he was the president, the accused, that is, and he was acting directly in command of the various agencies which you alleged carried out the crimes. Now, in those circumstances, there may be an argument for saying the two should be tried together, but Kosovo should be tried separately. Perhaps you might like to think about that and address us on it. And there is, of course, behind all this, while I am dealing with these matters. There is behind all this the manageability of the trial. I know you haven't reached that, and no doubt you will, of course, address us on it. But the sort of trial which you're arguing for, involving some 600 witnesses and lasting, I don't know how long you anticipate, Mr. Nice, but lasting some 2 to 3 years, is not one which at the moment would appear to be very manageable.
Can I deal with the first and last point? I'll deal with all three. We respectfully differ from the proposition that Your Honour advances for our consideration about the distance in time of one event from another, the lack of utility of the earlier evidence to the latter case. I think I've set out most of my arguments, but because of the way Your Honour phrased the question, I'll articulate it more particularly. Setting on one side the fact that in our respectful submission it is all part of the same overall plan, which of course supports our position in any event, in law, subject to discretion. This is a man, it may be discovered, who seeks to create or seeks to allow from time to time a distance between him and what may be shown to be his lawful duties, obligations and powers and crimes committed, we would argue, in his name. We may find specific reference to that from many of the, or from some of the very high-level politicians and military men who dealt with him. And so, whether he raises a positive defence on his own behalf or not, any chamber would be concerned to bridge the gap between act and who we say is one of the actors, the principal actor. What happened in his name, and we will say clearly to be established, in pursuit of the objective, led by him, controlled by him, what happened in his name became obvious by the time of those earlier conflicts. Obvious to everyone how the policy associated with him led to the commission of these grave crimes by those over whom he exercised influence and control. It was with that in mind that I alerted the Chamber to one of the linkage facts, that it's the same bodies, the Red Berets as an example, who we see in later conflicts, acting again to the will of this accused. And so that earlier evidence is indeed of great value and significance, and is evidence that we say the Chamber should have when it comes to consider what he knew and what expected. It is also, of course, not just of value under 7.1, but particularly of value in relation to 7.3. Your Honour's second observation was about the linkage of 2 but not 3. Of course we thought about it, but, and this is, although I have in large part the conduct of these cases in a general way, I nevertheless have to reflect a collegiate view on these matters, as you would expect in cases of this size. We don't just make decisions as individuals, although those having conduct of trials may be expected to do so, certainly in the heat of the trial. We've considered this matter very carefully, and we respectfully take the view, and press this Chamber to take the view, that that would be a wholly undesirable break. Preferable, of course, to 3 trials, but in itself undesirable. And can I now return, as I promised I would, to His Honour Judge Robinson's question about why to take Kosovo first would be undesirable. I'm coming to manageability as soon as I can. Well, let me deal with manageability in a sentence, because I'll deal with that when we come to look at the statistics. We invite you to say that, in fact, this trial will be entirely manageable as a three-part trial, and that there will be very, very substantial judicial economies that will result from it being a single trial. I'll make that point good a little bit more when I come to the statistics that we've put together. Dealing with His Honour Judge Robinson's concern at my proposition that to take Kosovo first would be, in our submission, undesirable. It would be undesirable for several reasons. First, of course, it is chronologically last, and therefore, if and to whatever extent a chamber hearing it realized that it did need material from earlier trials, there would be no possibility of using any of the evidence or conclusions in an earlier trial. And all it could do, this is perhaps an administrative problem, all it could do would be to take or invite to be led evidence of that earlier trial or trials, I beg your pardon, what would have been an earlier trial or trials, in great detail and to great judicial inconvenience. Second, there's the interest of the victims and witnesses. Victims and witnesses who suffered earlier would have their resolution, insofar as there is a resolution by giving evidence, postponed, possibly very substantially, by waiting for resolution of the later trial being heard first. Third, the first two indictments, as they are at present, the first two in time, Croatia and Bosnia, may be thought to be the more substantial and the graver. As a matter of general principle, it would be undesirable to postpone those trials, especially when they do come chronologically first, behind a trial that, although of course grave, as all matters before this tribunal are, comes later. Finally, the Chamber will appreciate that, although we don't know what, if any, defence the accused may advance, there is an entirely discrete issue in relation to Kosovo to do with the NATO bombings, which may occupy a great deal of time when it comes about. Now, the counter to that, and this is a general argument that we cannot press too strongly, the counter to all that is that what was happening in Kosovo, however engineered and manipulated, to whatever extent the accused may have relied on circumstances that fell into his lap when they did, circumstances that arose to his advantage, I can't use a metaphor as bad as that, when they did. And this can only be explained by seeing his conduct from the end of the 80s right the way through to 99 as a whole. So that, and then this argument is both positive in that it supports the application for joinder, and significant in that it goes to show how the evidence would become significant in any event if Kosovo started first, and then we'd all be in a difficulty. So, in answer to His Honour Judge Robinson's point, query of me, those are our reasons, and amongst our reasons, before we come to the question of management of time and use of judicial resources, that would point both in favour of a joint trial and, if not a joint trial, in favour of matters being heard chronologically so that later chambers can deal with earlier material in whatever way they so decide, once it becomes apparent from consideration of the material that is evident. Before I move on, and I know that I've taken some of your time.
Just one moment. Yes, Mr. Knight.
Microphone, please. Microphone, please.
Could I move to page 14 of the motion, the rights of the accused to a fair and expeditious trial? And I think the balance I've relied on there I've probably covered already, namely the balance between the accused having the right to explore matters that are favourable or exculpatory generally, because he won't be restrained, and the prosecution's ability to connect parts of history that have an evidential value of the kind I've already referred to. If we then turn to page 15, and some of the disadvantages for the accused of two trials, apart from the inevitably much longer time period over which he will be subject to judicial process here, there are several quite particular problems that he would face, exacerbated as they may be by his being unrepresented. Much evidence may have to be called twice. And of course, if it is called twice, as we know, lawyers spend inordinate amounts of time trying to find inconsistencies and differences and so on. These are exercises we know, I think he is a lawyer himself, he'll have to do, but while being on trial or facing the pre-trial phase of another trial. And at paragraph 37, I set out some of the problems of the extended pre-trial phases of these sorts of trials, because what would be, I respectfully suggest, certain if there were more than one trial is this. Those with conduct of the second trial, whether the same or a different chamber, would not be in a position to allow the thing simply to go into sleep for the time being. They'd have to be pressing on with it to make sure that it was ready. And so the accused would find himself in the position of having to cope with an extended trial, simultaneously coping with pre-trial phases. And then I come to judicial economy. But before I do, my friends who've been good enough to hand me a couple of notes have provided me with a few things before I pass from the general arguments. Can I just check myself that I understand them and deploy them now if it's necessary? Yes, and the first point I see is something I haven't articulated. There is indeed a match in the situations the accused found himself in Croatia and Bosnia, and then again in Kosovo, and the match again underlies the similarity of events and his response to them, a reflection of the identity of his plan. In each case, there was the risk of disintegration of a state, first the SFRY and then the FRY, and it was his response to the threat of disintegration, whether by the other states the other republics, I beg your pardon, or by Kosovo individuals and separatists that led to his reaction. So there is that additional feature of similarity. And while the disintegration of the republic was going on, the Kosovo movements that led to disintegration or the threat of disintegration were already underway. So it's a constant and continuing theme. I've taken you to the relevant paragraphs of the two indictments, but I'm reminded, this may be for a matter of reference, but I'm grateful to my learned friend for drawing it to my attention, that in the Bosnia and Herzegovina indictment, the Bosnian indictment, at paragraph 53, set in the context of the SDS and Karadzic, was the unification of all Serbs within one state. It is indeed simply another reflection in the drafting of the common theme upon which we rely. And it's all about the Serb control over territories. A Serb-dominated state, to include the Croatian and Bosnian parts, Kosovo, and so on. Can I now, and I'm very grateful for those points, can I now turn to the questions of judicial economy, and while doing so, deal with the first 5 questions that the court has asked of us specifically. The Chamber will not be surprised to know that estimates of time are difficult to make with any certainty. The Chamber was told on the last occasion the total number of witnesses for the 3 indictments that might be called. I have, as one of my priorities, been focusing on, as it were, the real statistics. And in doing that, I've had to engage really in 2 exercises. Exercise 1, looking at the evidence that may be reduced in number and quantity by either act of the prosecution or by proper exercise of its powers by the Chamber. Exercise 2, and I've touched on this already, looking at the likely important witnesses who will be available by trial starting soon or comparatively soon, who are likely to be of great value, but whose testimony again may lead to the possible reduction of time taken. And I explain that in this way. If you have a witness, perhaps an insider, who can cover a large amount of the territory and in a satisfactory and complete way, well, that witness can himself lead to a reduction in the number of witnesses who might otherwise have to be called to prove the same things in an indirect way. What I've also done is sought from my learned friends who've been dealing with the cases individually their own calculations of how long things would last. And in addition to my learned friends, Mr. Reinfeldt, Sir Retzalf, there is Mr. Groom, although he's not here today because he has commitments elsewhere, has been dealing with the Bosnian side of this case. And it may be that, although this is obvious, it's worth spelling out, that the principal factor determining how long a trial or trials will take is going to be the degree to which what is called crime-based evidence has to be given in person as opposed to by one of the mechanisms for evidence coming in writing, in particular under 92 bis. That issue is likely to be resolved, I dare say, in substantial part by the reaction of the accused himself, what attitude he takes to such evidence. And I can't help at all in relation to that at the moment. What we have done is to make a reasonable, we hope, forecast of the degree to which a chamber might accept evidence of crime-based witnesses to be given by Rule 92 bis. There are arguments for saying every witness should be here in person. There are arguments for saying that if there isn't going to be challenge, it should all be by 92 bis. Striking some medium position, I would respectfully suggest that the very most, in terms of crime-based witnesses, that the Chamber would be interested in hearing from in this case would be, in this case for all three indictments, would be 300. That's the very most. And if one works on the basis of how long their evidence in chief, because it's likely to be evidence that may not be substantially challenged, if it's just crime-based evidence, if one works on the basis of them being 2 a day, that's a maximum of 150 days. I would hope very much that that figure could itself be reduced, but that will be a matter for determination by, if it was one trial chamber by a trial chamber, or piece by piece by individual trial chambers later.
You've actually reduced your estimate now by half.
There are other witnesses as well.
It's crime-based, eh?
This is crime-based.
Yes.
This is crime-based. And this estimate allows for some witnesses in any event to be given by Rule 92 bis, but all we can do is make reasonable stabs and estimates, but one would hope that that figure might itself come down substantially further, particularly if, for example, it became clear that events on the ground weren't being challenged. As I express it in paragraph 42 of my motion, and I'll read this out because it explains, I think, our position accurately. It's the middle sentence. If the accused maintains his present attitude to the court, then both the trial chamber and the prosecution will have to perform the difficult task of deciding, without the benefit of argument from him, between allowing on a bare minimum of unchallenged evidence to prove the case and calling the amount of evidence appropriate to this very particular and unusual case. In addition to crime-based witnesses, there are the following general categories. Experts, and that's real experts, or they're constitutional experts, pathologists, demographers, and so on. They tend to be particular to one area or another, and if there were in total between 25 and 30 such witnesses for the 3 trials altogether, each taking a day, again, evidence in chief, that would be 25 to 30 days on top. Policy witnesses, and this is frequently witnesses at a very high level, sometimes with well-known names, are witnesses who it may be very difficult for us to call more than once because of their seniority. Witnesses who are likely to take longer. I've allowed for 2 days each, as a guess and as an average, with our experience in other trials to assist us. And my colleagues and I have calculated somewhere between 30 and 35 such witnesses might be available, so that they would take between them between 60 and 70 days on the basis I've advanced. Insiders, the last group, and as I've suggested, a group that may be growing and of great value, again, at present, we would forecast perhaps, and this is a very difficult forecast to make because of the concerns that such witnesses have, 25 to 30, again, 2 days each, 50 to 60 days. Simply putting those figures together and working on the basis of the 150 days that I hope would be the maximum required for leading evidence in chief from crime-based victims, leads, and taking average figures, leads to roughly 150 days for crime-based and very roughly 150 days for everyone else. 300 days in all. My learned friends, as I've explained, performed the exercise in order really to check the figures that I've reached differently and independently, how long their trials would take, their trials, our trials, but the trials over which they have presided as senior trial attorneys, how long they'd take. The ranges are of each trial between 13 and 9 months, 13 for Bosnia, 10 for Croatia, and 9 for Kosovo, maybe.
We need to deal with the Bosnia one separately. Could you give us the figures for Bosnia? We have got the figures for Croatia and Kosovo.
The estimate given by my friends recently may be slightly different, so I better check those. But the present estimate by Mr. Groom, and I don't disagree with it, but he knows the case much more fully than I do at the moment. The case for Bosnia is 13 months, but a significant saving if it would go together with another trial of 2 or 3 months. And in each case, there is, of course, a clear saving of time if trials go together of 1, 2, 3 months as a realistic minimum.
Yeah, how realistic, and I must ask you this, Mr. Nice, how realistic are these overall estimates? You see, we have references. The prosecutor told us on the last occasion that there would be 255 witnesses in relation to Croatia, 170 days, and the reference in Kosovo was 228 witnesses and 170 days. I mean, what you're talking about is a very different state of the case, it appears.
Well, I've done my best to build in my own experience, which is available to me from having run a big case, and knowing the degree to which witness lists are reduced by the time they come to court. I set this out in the motion. And if you return to the figures I've given for crime-based witnesses, I can explain that actually in more detail for you. It may help. For example, in Croatia, the suggestion is that there could be something in the order of 143 live witnesses for crime base, plus many other statements under 92 bis. But it's very difficult for us to forecast what percentage of material may go under 92 bis, because this is not our decision. We can make a decision to apply for that process, but it's a matter for the chamber to decide whether it will be acceptable. In the Bosnian indictment, let me stop there for a minute. We've tried to approach crime-based evidence in this way, generally. How many individual scenes of crime are there? Multiply every scene of crime by 2 witnesses per scene, per major scene. And that's been the sort of rule of thumb we've been applying. And that, indeed, if I go straight to Kosovo, because you've already had some figures for there, my learned friend Mr. Reinveld says that of the 167 witnesses listed for crime base, it may be possible to survive on as little as 42, not survive, to do justice by calling as little as 42, and the balance by 92 bis. Bosnia, which is at an earlier stage of preparation, as the court will appreciate, and which has 47 municipalities to deal with, has been approached on the basis that of the 300 witnesses dealing with crime base, approximately, 100, 2 per municipality, very approximately, should be called, and the other 200 could be the subject of 92 bis applications, thus reaching the total of about 150 300 that I said. I should explain that, of course, within crime-based witnesses, there are witnesses who are crime-based plus, that is, they can say something that begins to point towards the accused or that begins to explain the management process. But you can't have too many categories, and I hope the categories I've identified are helpful because they do enable us to have some sense of security in the figures we're offering you. Your Honour, those are the figures.
Well, the final matter is the state of readiness.
Yes. That's comparatively easy for me to explain. There are, of course, three things to be dealt with: 66A, 66B, and as a separate issue, Rule 68. As to 66A, the Croatia indictment will be completed, or is completed, on the 12th of December. So 66A for Croatia will be done. We have 30 days from today to comply with 66A for Bosnia, and subject to dealing with protective measures for witnesses, which is a motion that must be prepared, served, and although it's a difficult period of the year, responded to or dealt with by the Chamber. Subject to that, we believe that the 30-day period is realistic. Kosovo, of course, 66A has been done, so that 66A can be completed for all three indictments by 30 days from now. 66A2, not applicable yet for Croatia or Bosnia. So far as Kosovo is concerned, we understand from those who are dealing with the production of the materials, and I've been provided with a very helpful schedule, or we've been provided with a helpful schedule or sight of a schedule by my learned friend Mr. Kay for the Amici. I've got it, I mislaid it, I'm sorry. We understand that some 150 person days of work are left, and that with the resources being focused on this case, that material can be provided by the end of January. So that...
what are you talking about
66A2, which is the material to be served in respect of the trial. 66A is the confirming materials. Thank you for... there it is. Within the time limit, it's full disclosure of the statements of the witnesses intended to be called at trial and copies of written statements.
I thought all that had been done. We've had a pre-trial brief.
Translation difficulties mean that it hasn't been completed. It will be completed on present estimates by the end of January. And we now unearthed the missing statements. The Amici have very helpfully prepared a schedule which those dealing with the Kosovo team will be able to analyse and check that everything wanted or unserved will be served, as we understand it, by the end of January 2002. Your Honour, that brings me to the problem of Rule 68. And I know that this topic was touched upon at the last hearing. The prosecution entirely accept that it has its clear duty under Rule 68. It is also undoubtedly the case that as the material held at this institution grows, and wherever one is dealing with an accused of this category, the exercise under Rule 68 becomes increasingly enormous, and I do not use that word without careful thought. The exercise is one that I look forward, if it's possible, to discussing in detail and in due course with either the pre-trial judge or judges concerned, for I don't think it's going to be sensible to try and deal with it now. It is, of course, a continuing duty, one that continues right through the trial and indeed through to the appeal stage, as we know, of all these trials. Our problem is this with an accused of this kind. If we simply set parameters for the search of materials that may be relevant, then the task is absolutely enormous. Therefore, it becomes necessary, given that Rule 68 refers to what is practicable, it becomes necessary to set narrower parameters. With an accused who is represented, that is something that might be done more easily than with one who is not. And I can simply tell Your Honours this, that although there is continuing work being done in relation to disclosure under Rule 68, and although we've given thought to all sorts of possibilities, providing the accused with computer systems, if that were possible, but it probably isn't, and all sorts of other possibilities, there is, at present, and until we can be satisfied either by our own decision-making or by our own decision-making in conjunction with such assistance as the court or even the amici can give us, all I can say is that the outstanding duties under 68 will take a very long time to complete. May I explain what my intention is, although I haven't actually discussed this with my team yet, but I'll tell you in any event. I believe from recent work that I've done and meetings that I've had that we must prepare for the pre-trial judge in these cases, or this case, whatever it may be, a detailed account, rather like one that was served, I think, by Mr. Reed to the appeals chamber in Shoreditch, setting out exactly where we are and what we're doing. We are only too delighted to provide both to the court, to the accused, and to the amici the criteria for search that we will be pursuing, and only if we can narrow the present criteria very substantially will this exercise become a manageable one. With that...
So nice. I'm not sure what you mean by this. I understand the difficulty, but it must not be allowed to prevent these trials coming on. It must be conducted within those parameters. Of course, if you want the assistance of the court, you shall have it. But it's not to be, if I may say it respectfully, a way in which time goes by and trials don't come on. It's an ongoing problem here, trials not coming on.
I entirely agree with everything Your Honour said. We recognise it as a primary responsibility. I think Judge Hunt expressed it in the very appeal case to which I've referred. We certainly don't want it to delay trials, the reverse. I think that the test of practicability will reflect, as it were, the trial timetable, and I am optimistic that it will be possible to narrow the search criteria and to identify the appropriate behaviour of the prosecution, that we will be able to meet the trial timetable, whatever it may be, that the Chamber will set. But it is a huge task, and there's simply no suggestion that, for example, by February, or even, for example, were the Chamber to decide a midsummer start date, that the exercise could be completed by then, unless we went to the very, very narrowest of criteria. So that doesn't stand in the way of the trial working, of course not, but it does represent one of the realities of preparation. Your Honour also asked us in your list of questions about readiness for trial, and I'll just come to that. Kosovo, of course, is ready to start on the day in February, on the basis that it's prepared as a single case. I've already made my arguments as to the undesirability in our respectful submission of that happening. So far as the other two are concerned, there is time required, and I think that on the last occasion, 6 months or thereabouts, was identified for Croatia. Bosnia is in a less well-developed state and has been under very considerable pressure in terms of timing and resources. No doubt all those on the Bosnian case would prefer a longer period of time, but it's I who have to decide what we will make do with. And not make do with, because that's a matter entirely for the Chamber. Sorry about that. What I will say we could make do with and leave everything else to others. Given that there is the potential for continuing preparation of a case while it or an associated part of the same case are being conducted, especially if it was a joint trial, given the generalized power of the Chamber to make some variations in time limits under Rule 127, which might be a material power in relation to things like witness lists or final witness lists, I am reasonably confident that all these trials would be ready to start by the summer as a joint trial. Obviously, the Office of the Prosecutor would prefer the autumn, but we have to reflect on the interests of the accused and the public interest in having these cases heard and disposed of. And so, on the basis that there was a joint or single joint trial, we're satisfied that that date would be something we could work to. It would be very hard work, but we would do it. It will no doubt need some additional resources. I will ensure that I can get them. I will try to get them, and I'm confident that I will be able to. And so, Your Honour, that brings me to the end, at least at the moment, of what I'm saying. I'm sorry I've taken a long time, but this is a very important matter. I should say, for the benefit of the accused who may not have read the motion, that the other arguments we rely on... No, I must come back. So far as preparation of trials is concerned, there are many witnesses, and perhaps an increasing number, who can speak to all three indictments, particularly amongst the insiders and the high-level policy witnesses. Apart from the waste of time or the expenditure of time in their coming twice, there is always the real problem, particularly for insiders, of their willingness to come more than once. We also rely on the protection of victims and witnesses, and where such witnesses, insiders or otherwise, might be vulnerable, coming twice is particularly undesirable, or 3 times. And we urge the Chamber to say, and this is a reflection of the point made right at the beginning, and if I may respectfully say so, powerfully by the prosecutor herself, there is the interest of justice in having the accused dealt with, if there are any convictions, by a single chamber on a single occasion. And there are the wider interests of the interested parties in the former Yugoslavia seeing the matter resolved on a single occasion, whatever the result, by a single trial chamber.
Nice. On the question of the number of repeat witnesses, in your motion, I think you had identified a number of 25. Mm-hmm. Are you still with that figure, or is...
I suspect that figure is enlarging, and I use the word suspect, is going to grow. Oh. And I use the word suspect for this reason. There are 2 areas where, inevitably, we do not have the luxury of witness statements and certainty of what witnesses are going to say. One is insiders, and one is the very high-level witnesses to whom we only have limited access or don't get to them very often. And the work on those 2 categories of witnesses has been developing substantially recently, and it's in those areas that I think we are going to find, and we are finding, more witnesses who can help on all 3 areas.
Those repeat witnesses, would by and large not be victims?
No, they would by and large not be victims. Indeed, there may be none within those categories who could be described as victims, although there may be other from the mixed category of crime base and victims, the ones I said earlier, who can point somewhere up who may be victims. No, those witnesses would not be victims, but they may well be vulnerable to pressures, because of the position of this accused, and they may well be witnesses whom we only have the opportunity of calling once. We don't know that, but again, this is a matter of experience from calling such witnesses in other cases. The concerns they feel and genuinely feel may all too easily affect their willingness to turn up more than once. But you're quite right that they are unlikely themselves to be victims for the most part. Well, I don't know if there's anything else outstanding that help you at the moment. Can I just check my notes? Sorry, I think it was talking about 65 term. Yes. You were right about 66. Oh, sorry, yes. I think by a slip of the tongue, Your Honour referred to filing pre-trial briefs under 65 ter. I think it's 66. No, it is 65. Sorry, 65 ter E. Thank you. And Mr. Ryanville just makes plain, if I didn't make this plain, it's my mistake. In Kosovo, it's the statements of witnesses haven't already yet been served. That's the problem. That's a translation problem, because as the Chamber knows the problems, and of course the translation department, which serves all parts of the institution, has to set priorities, and there are a number of trials coming on in January, and they have to have their own priority. A considerable allocation of time has been made to this trial. Right. Thank you very much. Unless I can help you further.
Thank you, Mr. Nice. We'll hear the remaining arguments from the amicus and also from the accused at 2:30.